The important thing to remember about the Founders' Constitution is that it was a failure. It meant to bring peace, it instead brought war. It was meant to hold all the states together, to knit them into one nation. It instead rent them apart into various sections. In fact, if we go back and read the founders' great desires in the Federalist Papers, the entire purpose of the Constitution had been to avoid that kind of balkanization and bloodshed that the Civil War would bring in 1861. So when we talk about the Founders' Constitution, and we note, of course, that the text will survive, we must remember that it does not survive in its original form. And in fact, the Constitution will be dramatically changed during the Civil War, both by the actions of the war itself, the actions of the primary actors in the war, and as well by a set of constitutional amendments adopted in the aftermath of the war. The election of 1860 decisively reveals the flaw in the presidential election scheme that the Constitution held. First of all, 152 electoral votes were needed to win the presidency. 180 of the electoral college votes are located in the free states, 123 in the slave states. And Abraham Lincoln carried 180 electoral votes, but this 180 electoral votes was only achieved with 40% of the popular vote. So the system of electoral voting proves to be an absolute failure in 1860. That 40% of the vote was enough to carry each of the northern states. But of course, he doesn't win all of the northern votes. Many of the northern votes also went to Douglas. And Douglas, in fact, runs with a much larger tally of the popular vote. Well, actually, he doesn't. He only gets 29% of the popular vote, and for that, he only gets 12 electoral votes. And this is, of course, because in the South, people either vote for Breckinridge, who was the Southern Democratic candidate, or they vote for the Constitutional Union candidate, John Bell. This would immediately prompt South Carolina to act, and they hold a secession convention, and on December 20th of 1860 pass the secession ordinance. Now, it's worth noting here that there's a political angle. I'm going to talk about the constitutional implications of secession, constitutional origins of secession, but there's a political context to this, and that is that the ultras, the fire eaters, as they are sometimes called, in South Carolina, were aware that in 1850, when the southern states had met in a convention in Nashville, the meeting itself had proven an opportunity for the moderates to gain the upper hand, to counsel that they all tarry for the Congress to see what kind of political deal they can get. And in order to avoid the moderate victory, they know they must take action that will force other southern states into a position or the other. This was, by the way, the same kind of politics that were playing out during the nullification crisis. And it's notable that during the nullification crisis, South Carolina acts, but no southern state will follow them. We are now almost 3 decades later, and on December 20th, South Carolina makes its, cast the die and cross the Rubicon. And when they do this, other southern states will very quickly follow. By February 1, Mississippi, Florida, Alabama, Georgia, Louisiana, and Texas, which means, of course, that what you're seeing is almost immediate action by all of the Gulf states, all of whom secede. Now, the secession ordinance is a simple act of power, and it works off of the theory of ratification, of course. In fact, they go back to the ordinance of ratification and then assert that what they are able to do is simply unratify the Constitution, if you will, by an act of sovereign power. So they're putting forward the notion of state sovereignty as the linchpin for the Constitution and asserting their right to secede based on that. And this is, of course, heavily contested by a number of people who have claimed throughout American history that the act of ratification creates something larger than the state itself, and that once in, it can only be dissolved by the people themselves. But it's important to note here that the South Carolinians are not asserting a right of revolution. The right of revolution, although well, I shouldn't say that. They actually are asserting a right of revolution as well, but they assert multiple rights. And they are trying to cast secession as a constitutional remedy. And this, of course, is disputed by Northerners. It's disputed by Abraham Lincoln. It's disputed by many Southerners, to be perfectly frank. But on either grounds, they definitely put forward this theory, and it's upon this theory that other states will secede as well. They also issue a Declaration of Causes on December 24th, and the Declaration of Causes is modeled after the Declaration of Independence, and it makes clear that they have suffered, South Carolina in this case, has suffered multiple humiliations, breaches of promise by other states, and therefore that they have reason for this extraordinary act. So in this sense, they are admitting in a way that secession is extraordinary, that it is extra constitutional, if not unconstitutional, and declaring the reasons for it. And the reasons very clearly all come back to the problem of slavery and the place of slavery in the Constitution. Now, Lincoln's inauguration on March 4th was a very, very important moment. Lincoln equivocated, and he's very, very clear. He makes sure that everybody knows that the federal government will not assail the southern states. He tells them not to break. He also puts forward a theory of the Constitution that analogizes it to a contract. And analogizing it to a contract is important because what he is suggesting is that the Constitution itself cannot simply be walked out on by the act of one party. Once you enter a contract, of course, you are contracting in with other parties, and it is only with the consent of all parties that you may actually walk out on a contract. So the analogy to contract law holds South Carolina in. It's one way of theoretically holding them in. Meanwhile, South Carolina has sent slave commissioners to all the other states, and the other states as well send slave commissioners to the other slave states. And these commissioners attempt to convince other states that allow slavery to secede from the Union. Obviously, the slave commissioners are successful in the Gulf states, successful very early on, less so in the border states, including the Chesapeake, where they are having enormous difficulty. And this would all be brought to a head by the problem at Fort Sumter. And in Fort Sumter, what you have is a very, very nice chess match between the state of South Carolina and the Lincoln administration. The fort needed to be provisioned. The city eventually cuts off the provisions that it was allowing to the soldiers who remained in the fort. And it occupies a strategic position which is difficult to deny. It can close the harbor of Charleston at will. It cannot be assailed. Certainly cannot be assailed by land. And so in order to assail it, they have to begin building floating batteries that will be able to go out and launch cannon fire at the fort. And they began doing this. South Carolina, from December forward, is preparing an assault on Fort Sumter. And Lincoln announces this wonderful position where he says, all right, well, what we're going to do is reprovision the fort without relieving the people there. So he says, in essence, we're distinguishing this from a hostile act where we move troops into Fort Sumter. We're simply going to, as a humanitarian gesture, take them food. And South Carolina, rather than deal with this, on April 12th begins the bombardment of Fort Sumter, and on April 14th, the captain is forced to surrender. And so those are the first shots fired, or traditionally thought of as the first shots fired during the Civil War. Lincoln issues a proclamation on April 15th, and he calls for the raising of 75,000 militiamen, and they're placing them into national service. And this convinces northern states who had been under Democratic rule. New York, for instance, which was under a Democratic governor, had been very hostile to the idea of coercing the southern states back into the Union, now suddenly demands the military presence for Union. Stephen Douglas, who had been critical up until this point of Lincoln and of Republicans, of course, also immediately came out for war. Indiana, for instance, Lincoln had made this requisition. Indiana had been asked to bring out 6 regiments. The governor offers 12 into federal service. Now, the proclamation also pushes the other border states. The governor of Kentucky declares he will furnish no troops for the wicked purpose of subduing his sister southern states. The Tennessee governor says, we will not furnish a single man for the purposes of coercion. The Missouri governor, your requisition, Mr. Lincoln, is illegal, unconstitutional, revolutionary, inhuman. Not one man will the state of Missouri furnish to carry on any such unholy crusade. Similar replies come from other slave states, Virginia, North Carolina, and Arkansas. Curiously, Maryland and Delaware remain silent in the face of the requisition. But this really emphasizes just how important the Upper South actually is. And this isn't the Upper South, unfortunately, but we're looking at 8 states that exist above the Gulf states. And in those 8 states, we have 2/3 of the South's white population, 3/4 of its industrial capacity, 1/2 of its horses and mules, and 3/5 of its livestock and food crops. In other words, the Gulf states may have been the economic engine of the slave economy, but the Upper South was its strategic resources. So obviously the Upper South is immensely important to the cause of the southern states. And in May, largely thanks to what we saw at Fort Sumter, we have the further secession of Arkansas, North Carolina, Tennessee, and Virginia. Now, a pro-Union governor in Maryland keeps Maryland in the Union, refusing to call a secession convention. One is called anyway, and Baltimore actually breaks out in riots during this time. And on April 27th, Lincoln would declare martial law. And this declaration of martial law, the first in history, would lead to the arrest of people who were promoting secession. On May 25th, the Army arrested secessionists, including one wealthy landowner and lieutenant in a secessionist cavalry unit who had participated in Maryland's rebellion. His name was John Merryman. Now, John Merryman immediately applied for a writ of habeas corpus, and he applied for this writ of habeas corpus directly from the Supreme Court of the United States. Chief Justice Taney, from the chambers of the Supreme Court of the United States, issues the writ of habeas corpus. But for convenience's sake, he was in Baltimore at the time. He went to Baltimore where the Federal Circuit Court sat, and as Chief Justice of the Supreme Court, just as a single justice, here's the habeas corpus case. And here he actually, and the Army goes ahead and makes its argument about why it's allowed to arrest somebody. And he declares that, Taney, after hearing the case, declares that the imposition of martial law by presidential proclamation is an unconstitutional act. And he interprets the suspension clause here, and he says, listen, let's look at the way the suspension clause works. First of all, the suspension clause is in Article 1. And Article 1, this is a structural analysis, Article 1 defines the powers of Congress, and in this case, actually, the limits of the powers of Congress. But importantly, this means that it is not an Article 2 power. So the president does not have the power to suspend the writ of habeas corpus. Only Congress has the power to suspend the writ of habeas corpus. He goes a little bit further here as well, doing an historical analysis of it, which is frankly quite convincing. He points out that the power to suspend the writ of habeas corpus had been removed from the kings of England by Parliament, and the founders really would not have desired to grant the president more power than a king would have. Certainly, a Republican revolution would not have admitted such a great executive power. So he provides an historical justification for the suspension clause, implicitly granting the power to suspend habeas corpus only to Congress and not to the presidents. And finally, he looks at authorities. The authorities all agree that it is an Article 1 power. It lies with Congress. And then he says that you cannot claim exigency. He says that it is a delegated power, and as such, there is no implied power in the president to assume these extra powers simply because there's an exigent emergency. Abraham Lincoln ignored Chief Justice Taney. Ex parte Merriman's ruling that Merriman be released and that the proclamation of martial law be valid is essentially overruled. So in Ex parte Merriman, he should have been released had the courts been respected, but the military refuses to release him, and Lincoln refuses to honor Taney's ruling. Now, at this point, the Maryland legislature, which was in session, wants to consider secession and orders that a secession convention be held. And Lincoln immediately ordered that 31 secessionists be arrested. New elections occurred, and these produced for the legislature a victory for pro-Union forces. And the political prisoners arrested during this time. And there's no other way, by the way, to refer to the secessionists during this time other than as political prisoners. And that's what they were. But they were held until 1862, until the exigency, in essence, had passed. So it's a very strong political gambit, not a legal gambit, a political gambit that keeps these people locked up and keeps Maryland in the Union. Given the strategic importance of Baltimore, it sits along the railroad line, it carries troops into Washington, D.C., it connects strategic resources there. It's absolutely critical that he have this. Eventually, we start to see the remainder of the southern states making their choices. In Missouri, a pro-secessionist governor pushes the cause. War breaks out actually openly in Missouri, and in fact, in Missouri and Kansas, the war would be an absolutely brutal guerrilla war, house-to-house sort of things. A state convention is called in Missouri, and it actually rejects secession. And the governor and the legislature, despite that rejection, attempted to take the state to the Confederacy. And they are rejected, and by then Union troops arrive. And the result is that the governor and legislature go into exile and claim to be the legitimate government of Missouri. But nonetheless, they are essentially a government in exile for the remainder of the war. Kentucky, you have mixed traditions, and the attempt to follow the tradition of Clay, Henry Clay, as a mediator means that many in Kentucky are reluctant to secede. They are heirs of the Jeffersonian tradition, and Jefferson himself was quite ambivalent on this point, and he did not believe in secession. He makes this quite clear. The split is very real, by the way, within the state. There are 7 grandsons of Henry Clay, by the way, who will fight during the Civil War. 4 of them for the Union, 3 of them for the Confederacy. One slave state did not split at all, and that would be Delaware. 2% of its population were slaves. 90% of its black population was free. Delaware remains with the Union. During this time, Virginia will split. This is where the state of West Virginia comes about. Western Virginia was decidedly anti-slavery. They hated the political power of the slaveholders of the East, and so they push they actually have their own sort of state secession movement, and West Virginia is formed as a result of it. Now, a national draft would ultimately have to be called. The militias, as I hope I've discussed this before, militia powers were absolutely useless as a means of organizing a national force. And the result is, of course, that to create a national army, you need something like a national draft. And Lincoln began toying with it. This had been a long-standing constitutional question, and most constitutional authorities in the early republic had stated that it was impossible to call a national draft. Nonetheless, the president does so, and a national draft would be called forward. On September 24th of 1862, Lincoln suspended the writ of habeas corpus in the North in order to enforce the federal draft. There are people who are opposing it on these constitutional grounds, and he wants them arrested, and he wants them not to have recourse to the courts. Congress was not in session when he does this in 1862. But on March 3rd of 1863, Congress would retroactively approve the suspension of habeas corpus. This is a fairly dramatic moment. It's one thing in 1861, in the face of a riot in Baltimore, for Lincoln to claim presidential authority to suspend the writ of habeas corpus, and then to ignore a Supreme Court ruling saying, you must release this person. For him to do this a year later, after Congress had sat, even though it was not in session at the time, is a remarkable assertion of presidential authority. And the suspension of habeas corpus is much broader. It's not just in Maryland, but it's across a line that he draws, and people above that line are subject to military arrest. And in fact, they are then subject to trial by military commissions. So in 1862, presidential power extends even further, and then Congress in 1863 essentially rubber stamps this. And this is used, by the way. Civil liberties start an inexorable downward decline during this time. There are elements of a loyal Democratic opposition, rooted obviously in the Democratic Party, to Lincoln in the North. And Clement L. Vallandigham, an Ohio Democrat, would be arrested and then tried by a military commission. And once again, he is really nothing more than a very vocal opponent of the president during the war. Now, New York Democrats would severely protest Vallandigham's arrest, and Erastus Corning, the leader of this Democratic protest of Vallandigham's arrest, published a letter protesting the arrest. And Lincoln's reply to Erastus Corning is called the Corning Letter, and it's a very important document in our history of civil liberties. And it's not one that reflects favorably, if you are a fan of the tradition of civil liberties in the United States, it does not reflect favorably on Abraham Lincoln. In the Corning Letter, Lincoln said that Southerners hope to keep on foot amongst us a most efficient corps of spies, informers, suppliers, and aids and abettors of their cause. So he's identifying people who are directly aiding and abetting the enemy, which of course raises the language of treason. And he says that they operate under the cover of, this is quote, under the cover of liberty of speech, liberty of press, and habeas corpus. Lincoln goes on further to say that the Confederates knew that their friends would make a question as to who was to suspend the writ of habeas corpus under the Constitution. So he's now suggesting that anybody who raises this constitutional issue is perhaps a friend to the Confederates, and in fact perhaps somebody who is treasonously aiding and abetting the cause of the enemy. Any such argument, Lincoln goes on to say, any such argument about the Article 2 power to suspend the writ of habeas corpus is part of the enemy's program. Further, silence itself is is proof of disloyalty. Lincoln, I'll quote here from the letter, "The man who stands by and says nothing when the peril of this government is discussed cannot be misunderstood. If not hindered, he is sure to help the enemy. And if he blinks, if he uses ifs, ands, or buts, he is just as disloyal." So the Corning Letter, Lincoln's reply, asserts a strong prerogative on the part of the president to be able to act against Confederates. And Secretary of State William Seward delivered his Allies of Treason speech during the 1864 campaign, and in essence suggests that even not voting for Lincoln is itself a treacherous act and one that allies somebody with a treasonous design. Seward, this is by the way a man who at one point boasted that he could simply ring a bell and have any man in the United States arrested. And he's not far from the truth here. So during the war, civil liberties take a fairly dark decline. Other things also happen, which might be more positive if you are a fan of civil liberties. For instance, Abraham Lincoln moves immediately to have his Attorney General reject some of the more controversial parts of Dred Scott. For instance, ruling that African Americans, the descendants of slaves or not, are in fact citizens of the United States. Also holding that Congress does have power to ban slavery in the territories, and then beginning to actually take action against them. In 1861, on August 6th, passing the Confiscation Act. And this declared that any property used in support of the rebellion and seized by the army was to be appropriated. And this, by the way, begins when you start saying that you can seize property by the enemy, the question of slaves as property starts up. And slaves began identifying themselves this way. They call themselves contraband property. By one estimate, thanks to the Confiscation Act, 200,000 self-liberated blacks, and those liberated by the army as well, would work for the Union Army by the end of the war. The 1862 Confiscation Act declared that contraband slaves would be forever free. And in 1862, Congress would outlaw slavery in the District of Columbia and in the federal territories, completing, in essence, the end of the rulings of Dred Scott. Further, by the way, undermining the authority of the Supreme Court. The Supreme Court will emerge quite weakened from the Civil War. Finally, of course, the Emancipation Proclamation, which was actually issued on September 22nd of 1862 and would take effect on January 1st of 1863. And this, of course, very famously declares forever free slaves in the states that are still in rebellion at the time of the signing of the proclamation. So by 1863, if this was a war that began to hold the Union together, there can be no question that by 1863 it is a war to end slavery. The ending of slavery proves to require actual constitutional action, and this, of course, occurs with the passage of the 13th Amendment. It passes the Senate in 1864, and then in 1865 receives the appropriate vote in the House of Representatives. Thereafter, the 13th Amendment goes to the states for ratification, and it's ratified only through extraordinary procedures. That is to say, a lot of the states that actually ratify the 13th Amendment do so under duress. They are required to ratify it in order, as they believed at the time, to re-enter the Union. And this is something rather important. When you look at the 13th Amendment, we have to wonder precisely what it is it does, which is simple, and what it does, which is radical. I mean, is it a radical bill or a radical amendment? Obviously, it's radical in the sense that it destroys a tremendously valuable asset. It acts against property in a way that Congress had been doing during the war, but this purports to do it during peace and forever after. It also, it's worth pointing out here that slavery, which was not supposed to exist in certain parts of the United States, had in fact existed there. The Northwest Ordinance, for instance, had declared that slavery should never exist in the Northwest Territory, and state constitutions, in fact, had outlawed slavery in the Old Northwest. But it's worth pointing out that slavery did exist there, in contravention both to the Northwest Ordinance and to state constitutions. There were, of course, many ways for people to impose servitude on people without necessarily declaring them slaves. But the 13th Amendment is radical for another reason, and that is that the enabling clause affects a change in the way the Constitution works. Section 2 reads that Congress shall have power to enforce this article by appropriate legislation. You'll recall, of course, that the necessary and proper clause, which had been the operative clause which extended congressional power under the Founders' Constitution, had been the source of the greatest controversy in terms of interpretation. What precisely did necessary and proper mean? This standard is abandoned in the 13th Amendment. Congress shall have power to enforce this article by appropriate legislation. This directly recalls McCulloch v. Maryland and the standard laid down by John Marshall, which of course he had gathered from Daniel Webster and Alexander Hamilton. In short, the old Jeffersonian Constitution is giving way to a Hamiltonian one. We see this occur as well with the 14th Amendment. And I'm not going, because this is the very last lecture, the very last day, I'm not going to talk about the passage of the 14th Amendment, except to mention that it is presaged by the Civil Rights Bill of 1866, which granted much of what we see in the 14th Amendment. And the Civil Rights Bill of 1866 was, in fact, vetoed by Andrew Johnson, who claimed that it subverted constitutional principles. So he exercises the veto on April 9th, he exercises the veto to to prevent what he believes to be an unconstitutional bill. Congress overrode it, but then decided that in order to secure the rights that the Civil Rights Bill was laying out, that they would also require an amendment, a constitutional amendment, to make sure that they could constitutionalize it. There's a number of people who oppose the idea of amending the Constitution, partially because they believe that the Civil Rights Bill is constitutional and therefore feel that the 14th Amendment is superfluous. So opposition to the 14th Amendment does not just come from Democrats or from states' writers, it also comes from radical Republicans as well. There was also a great concern about how, in fact, you would enumerate all of the rights of a citizen of the United States or all of the powers of Congress in order to enforce such rights. And so the language ends up being a very distinct compromise, and a very important one, because the 14th Amendment would in fact change the Constitution forever. It has essentially 4 clauses in Section 1 that enunciate a new kind of constitutional order. First of all, declaring natural-born citizenship for all people in the United States, and then including 3 clauses that restrict state action in new ways. The Privileges or Immunities Clause. This is different from the Privileges and Immunities Clause in Article 4. The Due Process Clause, again, specifically applying to the states, so separated from the Fifth Amendment. And then the Equal Protection Clause. This, the first of its kind, really, also enunciated a principle which had been operating in American law and constitutional law for some time, but now it enunciates it. And of course, in Section 5, the Enabling Clause, Congress is given appropriate power, a power to pass appropriate legislation to enforce the 14th Amendment. The final, and there are tremendous constitutional stories that go along with this. Andrew Johnson, who would continue to veto the legislation of the Republicans, found himself being impeached. He was impeached, and he came within 1 vote of being removed from office. It would have been the only president removed from office had it worked. So he's impeached but not removed. It actually is usually hailed as a victory for the presidency, because it indicated that even an all-powerful Congress could not simply command the president and turn him into a mere minister. And finally, the 15th Amendment rounds out the Civil War amendments. And the 15th Amendment is a whole other problem. It actually doesn't guarantee any rights. It simply prevents states from using race as a specific means of depriving people of the suffrage. And the interpretation of the 15th Amendment, indeed the very enforcement of the 15th Amendment, and for that matter the 14th Amendment, would not have a very robust history in the 19th century. It would take another century of jostling over the new Constitution to create a civil rights regime. And so this brings the Founders' Constitution to an end formally. The 13th, 14th, and 15th Amendments create a new Constitution, and it requires a reworking of all of the branches of government, which have been, of course, drastically changed by civil war and by the emergence of political parties. In short, we've seen a dramatic change in the constitutional order, of which the 13th, 14th, and 15th Amendment really cap a kind of new way of thinking about the Constitution, as well as a new Constitution itself.